All right, good afternoon. This is Beth Overmo, Strategic Plan Coordinator for the State Bar of South Dakota. I just want to welcome those who are attending our Law for Lunch August seminar today on immigration law. This presentation will last between 30 to 40 minutes. There will be an opportunity for questions at the end, but we also welcome you to post questions using the questions toolbar. Uh, Everyone who is attending this webinar is in listen-only mode, and so the only way that we are able to receive your questions is through that questions panel on GoToWebinar. And now to our presenter, Kathy Moccio joined the James H. Binger Center for New Americans in August 2017 as a visiting assistant professor of clinical law. She has more than 25 years of experience practicing immigration law. From 2009 to 2017, she served as an assistant Hennepin County public defender, a position in which she helped non-citizen defendants navigate the intersection of criminal and immigration laws. She is recognized nationally as a researcher, author, and educator of lawyers on such CrimImm issues. Prior to her time with the Hennepin County Public Defender's Office, Kathy was in private immigration practice at a number of firms, including Minneapolis-based Dorsey and Whitney, and also worked for and consulted with numerous immigration nonprofits. Kathy has long been active with the Binger Center's nonprofit partners, as well as such national organizations as the American Immigration Lawyers Association and the American Immigration Council. In 2015, the National Immigration Project of the National Lawyers Guild selected Kathy as the sole recipient of its annual award in recognition of her outstanding contributions to the cause of immigration justice. And with that introduction, I'd like you to welcome Kathy Moccio as our presenter today. Thank you for joining us, Kathy.
Thank you very much. Thank you, everybody, for being on this webinar. I think all of us are familiar that immigration is a very hot topic, and regardless of whether you practice criminal law or immigration law, you may represent an immigrant and they will have questions about, well, what can I expect if I have interaction with the court system? And so today, the presentation, while it is really focused on the intersection of criminal law and immigration law, I hope it will provide some tidbits for all of the various practices that may be represented in attendees today. As far as criminal defense lawyers, the intersection of immigration law is particularly important because of the 2010 Supreme Court case, Padilla versus Kentucky, which held that a defendant's Sixth Amendment right to counsel includes the right to competent advice about the immigration consequences of conviction. And so, that is certainly something that is front and center in a criminal defense practice, is if you represent a non-citizen defendant, to make sure that you understand the immigration consequences. The presentation will go through a little bit of a background, just some of the processes, how do people end up in immigration custody, and then work through some of the substantive statutory sections that impact representation of a non-citizen defendant. Okay, as an introduction, who are the parties that get involved in the enforcement of immigration law? Well, first of all, local police and sheriffs can have a very important role in identifying non-citizens. Often, local police will contact ICE for a stop. Sometimes that's for interpreters. A number of times we've seen local police call Customs and Border Protection or Immigration and Customs Enforcement for assistance with an interpretation, or to ask if the person that is being stopped is a person of interest for immigration. Local sheriffs during booking process will often notify ICE that a person is in custody and give ICE access to a detainee. We've also seen instances where somebody from the court system themselves may have notified ICE, and particularly probation. We've had probation officers that have turned individuals over to ICE when people have reported for probation appointments. So those are some of the ways that local organizations may work with immigration. Customs and Border Protection are typically present in the airports and also at the border. They do the initial inspection of individuals when they come into the United States. So if you have somebody, for instance, who has a green card, a lawful permanent resident, they may have been convicted of a crime, they leave the United States, Customs and Border Protection is going to question them about that crime and may take them into custody and hold them in custody until they determine whether or not the person is able to lawfully return on the visa status that they have. Immigration and Customs Enforcement is an organization that is engaged in enforcement inside the United States. So they are the people that conduct raids at places of employment. They will go to a house to conduct an arrest. They will show up at courts to arrest individuals of interest to them. Some of the mechanisms that are in place, there are what are called 287G agreements, which is actually the federal government deputizes local police to enforce immigration laws. I could not find any 287G agreements that are in place for South Dakota, but South Dakota does participate in secure communities. And what that is when an individual is fingerprinted during a booking process, those fingerprints go to the FBI, and then the FBI forwards those to the Department of Homeland Security, specifically to Immigration and Customs Enforcement, known as ICE. And ICE then takes an interest in people who they identify as somebody who may be removable. There is also the Criminal Alien Program, commonly called CAP, and that is a much more informal program. It's hard to tell exactly how that works sometimes, but the basics are that when somebody is booked into a jail, the sheriff will contact ICE and let ICE know that the person is there, and that give ICE notice of why they are there. In Hennepin County, where I worked with the public defenders, the sheriff Stanek, his process was to allow ICE to directly talk to the individual and gather any information they wanted. That was extremely problematic for detainees because at no time were detainees told that the information that they were providing would be used against them, and often it was the information that was needed for immigration to prove that the person was in fact removable. Once immigration is aware that a person is held in a county jail and that the person may be a person of interest to them, they will lodge a detainer. And that detainer is a request to the sheriff, one, to either hold the individual for up to 36 hours, not counting weekends and holidays, for ICE to pick up, or two, to notify ICE when the individual is going to be released so that ICE can pick the person up. Most detainers used today are notice detainers, so the sheriff is asked to contact ICE. We have seen a couple of instances in South Dakota where a person was not allowed to pay bail, even though the judge set bail, but the sheriff did not accept the bail payment because ICE had lodged a detainer on a detainee. So that's, detainers are something that of concern in South Dakota. And if you have instances where you have a client that was granted bail but not allowed to bail out, certainly please let me know. That's something we're very interested in tracking. We have seen instances where people are paying their bail, the detainer is there, ICE is notified, a sheriff goes ahead and releases the person, but as soon as they walk out the jail, they are taken into ICE custody. So, how do you know what to expect with a non-citizen client? I mean, as far as advising them about, look, if you pay a bail, you're actually going to be able to go home to your family, or you're going to end up in immigration custody, or, to determine what the consequences of arrest and possible conviction are. First thing is to find out what's the person's immigration status. And really, we put that into two broad documents. Unless the person's a U.S. citizen, are they undocumented, which could be somebody who came across the border illegally, or somebody who had a lawful status that violated a term of that status, or are they in a lawful status such as a green card, a foreign student that is in full compliance with the terms of their educational program, somebody that's working, for instance, temporary agricultural workers that are in compliance with the terms of their visa, or temporary professional worker. those are some of the statuses. And that's vitally important to figure out what is that person's status. The other thing is, what is that person's goal? I think a lot of times people assume like, well, the person wants to stay here, that's why they're here. And that's not necessarily true. I think once people really start looking through what are the options that they're facing, they're going to start making a decision. Do they really want to be in the United States or not? Once a person is released from criminal custody to ICE custody or released from a police stop to Immigration and Customs and Enforcement, ICE is going to make a decision about bond. In immigration, it's called bond, and it's governed under the Immigration and Nationality Act, Section 236. Some people are not eligible for bond. They are held in mandatory immigration custody until the completion of the removal case. And some of the things that would subject an individual to mandatory immigration custody: conviction for a controlled substance offense, conviction for certain crimes of moral turpitude. Definitely those are people that are going to be held in mandatory custody. They're not going to be bond eligible. For individuals who are bond eligible, prior to this administration, people regularly were able to bond out of immigration custody, and ICE itself typically would set a bond for an individual. Now, what we're seeing is that most people taken into immigration custody rarely does ICE set a bond for the person. So what that means is the person is held in immigration custody. They have to request a hearing in front of an immigration judge. Those hearings can take anywhere from 3 weeks to 6 weeks. Immigration judge it's a very short hearing, and typically the immigration judge is going to be focused on two factors. One, is the person dangerous? And two, is the person a flight risk? And what we're seeing is that it is very difficult to get bond out of an immigration judge if there's any type of pending criminal charge. And a lot of times there are serious issues with the immigration judge wanting testimony from a respondent on what happened in the criminal case. And so, people are forced to make some very tough choices between exercising their Fifth Amendment right not to self-incriminate and trying to get bond. So, that's an issue that we're facing every day in immigration court hearings. Bond hearings from immigration court are very, very high. For instance, on a DWI, a pending misdemeanor DUI, I haven't been able to get bond for less than $2,000 for somebody, and that's with no other criminal record. So I think that gives you a little bit of an idea of how high immigration bonds are. Not uncommon to see a $7,500 or $10,000 bond for somebody in immigration custody. Increasingly, judges are refusing to grant bond based on dangerousness due to pending criminal charges, and there's a rise in federal habeas corpus proceedings. That's something that we have a litigation clinic at the Vineyard Center, and they are handling a number of habeas petitions for individuals with pending criminal charges. So that's kind of the background, how people end up, the process that people end up in immigration custody. What are some of the sources of immigration law to try to sort out, well, what's going to happen to somebody who has a criminal charge? There are a number of sources of immigration law. First, there's the statute, which is 8 U.S.C. or the Immigration and Nationality Act, and the grounds of removal are listed in Immigration INA 212 and 237. And going back to that preliminary step of identifying the person's status, that's vitally important, because if the person was lawfully inspected and admitted, they're going to be subject to the grounds of removal under 237. If the person is undocumented because they entered without authorization, they're subject to the grounds of removal under 212. So again, identifying what the person's status is and their way they entered the United States is important to identifying which grounds of removal is going to be applicable to them. The statute also identifies relief, so whether or not the person has a way to ask an immigration judge to stay in the United States. The second source of immigration law is administrative action and guidance, and that is where a lot of the action is in the current immigration environment. For instance, something that's been getting a lot of press is the separation of children from parents at the border. That's an administrative action. That's decision that this administration has made. Another administrative decision is the bond situation, not a default of detention as opposed to release as presumed. That's another administrative decision that's been made. So that's a very volatile area. A high number of administrative directives have been issued since January of 2017. The third area of source of law is the immigration courts, and that's the immigration judges, and then the Board of Immigration Appeals is the highest administrative appeal agency within the agency, and then the federal courts. From the Board of Immigration Appeals, a case goes to the Federal Court of Appeals, and then to the Supreme Court. The Supreme Court has issued a very high number of immigration decisions on CrimImm cases, and we'll go into a couple of those later in the presentation today. And just as kind of an example of some ways administrative consequences might impact a non-citizen. DUIs, I think I mentioned very high bond for somebody who has a pending DUI. But DUIs are nowhere in the statute as far as an immigration consequence. So again, you just have to kind of look out for what is the agency saying about DUIs. Well, for instance, the Obama administration designated DUIs a significant misdemeanor. What does that mean? That means if you're convicted of a DUI, you are not eligible for deferred action for childhood arrivals. So if you have DACA or you're a dreamer, you're not going to be eligible for that work permit or designation any longer. Second of all, DUIs are, the government regularly argues DUIs are inherently dangerous. And so again, dangerousness is a bond factor, not going to be very difficult to get bond if you have a pending DUI. Third executive way that DUIs have come into have significant immigration consequences is visa avoidance. Last year, the U.S. Department of State indicated that a person who is charged with a DUI, their visa is now going to be void, which means that the person can lawfully be in the United States working as a temporary worker or lawfully attending school. But if they leave the United States, they have no way to come back because that visa is void because of the DUI. It's also going to result in extended processing delays if the person tries to go to the consulate to apply for a new visa while abroad, because they're going to look at whether or not there's a chemical dependency issue. So DUIs can have extreme immigration consequences or severe immigration consequences, even though you don't find them on either 212 or 237 as a grounds of removal. Let's take a look at the immigration statute and how it impacts a criminal law practice. First of all, the definitions. I think one of the things that is important to know is that immigration has a definition of conviction that is found at INA 101A48, and that conviction is much broader than that which is typically used in criminal law context. So for instance, a person who admits to some type of action, a judge stays adjudication on that, and then the person completes probation and the charge is dismissed. That is a conviction for immigration purposes. The fact that somebody admitted to wrongdoing and there was a restraint on liberty, that's a conviction regardless of whether or not the criminal law, criminal court considers that to be a conviction. So that's an important distinction people need to be aware of. The second thing is term of imprisonment is defined under 101A48B, and that includes stayed time. So if you get a stay of execution, that stay, that amount of time that stayed counts towards a term of imprisonment for immigration purposes. That's very important to know. Likewise, it's important to know that probation does not count as a term of imprisonment. So if you get a pure probationary period, that's not a term of imprisonment for immigration purposes. Another thing that's statutorily defined is aggravated felonies. They're at 101A43A. It's a long laundry list of crimes. And it's important to note that some of the crimes that are considered aggravated felonies for immigration purposes are not felonies at all under state law. So it can be a misdemeanor in some instances, can be considered an immigration aggravated felony. And then finally, good moral character is something that's very important for immigration relief. And so whether or not the person is going to be able to stay in the United States if they end up in deportation proceedings. And that is defined at 101A, or excuse me, 101F. And one of the things that is on there is term of imprisonment, 180 days, can void good moral character. That's something to be concerned with sometimes. The other thing is chronic alcoholism. So when somebody has a lot of DUIs, they're going to run into issues with good moral character. Some of the myths that I used to hear a lot at the public defenders is that diversion or state sentences that don't result in a conviction are okay. We've already talked about that. No, not necessarily. If the person's making admissions to the court and has some type of restraint on their liberty, probation, fine that needs to be paid, that's probably going to be a conviction for immigration purposes. Sometimes if there are diversion programs where the person does not make admissions to the court but goes into some type of programming, and then if it's successful, the court just dismisses without admissions, that may be successful in avoiding a conviction, but really need to check very carefully because that's an area where there are some changes happening in the law. The other thing that I used to hear a lot is a sentence of 364 is safe. As long as you can avoid a felony sentence, you're okay. That's not necessarily true. Again, you have to look at, what does the immigration statute say is the trigger to an immigration consequence? If the statute specifically says a term of imprisonment of a year, then a sentence of 364 may be okay. But otherwise, definitely need to look at that very carefully. Can't presume it's okay. Non-felonies, again, that's a myth because misdemeanors and even petty misdemeanors and sometimes can have drastic immigration consequences. Petty misdemeanors, so not a crime in Minnesota, for possession of a small amount of marijuana, that can subject somebody to removal and mandatory immigration custody. So, really need to look at what the consequence, how the INA says the consequence is triggered. And then finally, if not a grounds of removal, there are no consequences. Again, not necessarily because the person may not be able to travel, may not be able to ask for relief from removal if they end up in deportation. Let's turn from the statute to some of the court interpretations of the statute. What the U.S. Supreme Court has set forth the framework to determine what are the immigration consequences of criminal activity. And the immigration statute in a number of places says pegs a consequence to conviction. And so when you look at the immigration statute, it will say non-citizen or alien convicted of is blah, 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 deportable, okay? And again, the U.S. Supreme Court set forth the approach. It's called the categorical approach. And what that test is, or that approach is that you look at the elements of the state statute of conviction as well as the elements of the federal crime that forms the generic basis of removal. It is an element-based approach, not a conduct-based approach. It doesn't matter what the person did. What matters is what is the minimal conduct a person can be convicted of, and does that rise to the level of a grounds of removal? Okay, let's just kind of walk through one example. A crime that immigration often charges as a grounds of removal is an aggravated felony crime of violence. It's defined under 101A43F. And the trigger for that is a person convicted of a crime of violence for which they receive a term of imprisonment of 1 year. And again, that's 1 year state. So it could be a crime that's less than a felony in many states. The U.S. Supreme Court this year decided a very important case called DiMaia, which struck down part of the definition of crime of violence. It used to be that somebody who was convicted of a felony during which the commission, it was reasonably foreseeable violence could be used, that was a crime of violence. And a typical example of that is fleeing the police. Somebody who had a felony charge of fleeing the police were almost always found to be removable for a conviction for a crime of violence. Now, a person is only removable if the state crime itself has an element related to the use, attempted use, or threatened use of physical force against the person or property of another. So it could be an offense that's a misdemeanor level, but as long as the possibility of getting a sentence of a year, if the person is sentenced to a year, even if it's stayed, that can be a crime of violence. So gross misdemeanor, for instance, in Minnesota, could be a crime of violence if they get the top of the box. The force has to be violent force. And that's set out in a Supreme Court precedent called legal call. So that's crime of violence. Another area that is of high interest to people is controlled substances. Again, a U.S. Supreme Court decision in Mullooly indicates that a person has to be convicted of possession of a substance that is on the controlled substance schedule. And this is an area of litigation. And looking at the South Dakota statute, it depends on whether or not the state requires you to prove the actual substance possessed in order for you to have a conviction. Or is it sufficient that the substance is on one of the schedules? And so that is an area that's been litigated a lot. If you have a controlled substance case that you're trying to, or that you're working on, I'd be very happy to talk to you about that. It's a very detailed argument. We've done a lot of briefing on that. We'd be happy to share briefing. We have a couple of cases pending in the 8th Circuit right now on this issue. But again, it really goes to, does the state law require you to prove the specific substance? And if so, is that substance one that is on the federal controlled substance list? Crime of moral turpitude is something that's listed in both 212 and 237, and I think people get a lot of questions about, is this a crime of moral turpitude? Crime of moral turpitude is defined by the courts. It's nowhere defined in the statute. And there's two requirements in order for a crime to be a crime of moral turpitude. First of all, there has to be an element of intent, specific intent, deliberateness, willfulness, or recklessness. Negligence is not sufficient. Okay, so if you have a crime of negligence where that's the mens rea, not sufficient to rise to the level of crime of moral turpitude. Second of all, in addition to intent, there has to be some reprehensibility. The crime has to be inherently base, vile, or depraved, and contrary to the accepted morality and the duties owed between persons or to society in general. There's been some litigation over vagueness for crime of moral turpitude, because who knows what is inherently base, vile, depraved? Very difficult to often peg accurately what is a crime of moral turpitude. As of today, courts have not been willing to strike down crime of moral turpitude for vagueness. I thought we could maybe just go through a little bit the South Dakota theft statute. It says that anyone who takes or exercises unauthorized control over property of another with intent to deprive that property of person is guilty of theft. And I don't know South Dakota law, so one of the questions that I have about this statute is, does it include crimes of fraud, where if a person fraudulently takes the property, if that's an element, then perhaps it's not theft, because the definition of theft for immigration purposes does not include fraudulent takings necessarily. The other thing is intent to temporarily deprive. So if the person can intend to temporarily deprive, that does not rise to the level of a crime of moral turpitude, because the immigration taking is a permanent intent. So that is another area maybe to look at a little bit with the theft statute if you have a non-citizen who's charged with that crime. If you have a temporary taking, you need to be careful that there's not a diminution in the value of the property, because there was a recent Board of Immigration Appeals case that said a temporary taking, which results in a significant diminution in the value of the property, is a crime of moral turpitude. Another crime that I looked at that I thought might be interesting just to talk a little bit about is assault. Is it a crime of moral turpitude? Not necessarily. Under the South Dakota statute. South Dakota statute actually has a number of different crimes that are considered assaults. And so, applying the categorical approach, if you are convicted under subprong 3, and it's clear that the conviction is subprong 3, then it would not rise to the level of a crime of moral turpitude because the intent is negligent. Negligent causes bodily injury. So that would be a way. If it's not clear what prong you're convicted under, then the immigration court is going to go through the record of conviction to determine what crime was actually the conviction was for. It's important to note that a conviction is not always required to trigger an immigration consequences. For instance, controlled substance trafficking. Conviction is not required for that. There just has to be sufficient allegations for the government to find that the person was involved in controlled substance trafficking. Admissions to the elements of a crime of moral turpitude is sufficient to trigger grounds of removal in 212. You do not need a conviction for a crime of moral turpitude to trigger the immigration consequence. And then another area that's a very hot topic in immigration law is violation of an order for protection. A finding of a civil violation is sufficient to make a person removable under 237. So a lawful permanent resident who admits to a violation of an order for protection in a family law proceeding is going to be removable under 237. They're also going to be subject to immigration custody. They are, however, bond eligible. So what are some of the tools that you can use to defend a non-citizen? And that's a lot of what I did at the Hennepin County Public Defenders, is really trying to create a toolbox for lawyers to use to represent their clients. Some of the an illustration of some of the options are negotiating a different charge. So, for instance, going back to that assault statute, maybe you have an individual that's charged under subprong 1 or no particular subprong is identified. Could you negotiate to subprong 3 where they acted negligently to avoid the crime of moral turpitude? That's a good example. Other examples may be instead of a controlled substance charge, is there some other type of charge that they may be subject to? DUI sometimes, instead of when there's somebody under 21, sometimes we would try to negotiate minor in possession. Again, just trying to, negotiate away from something that had the immigration consequence. Another thing that we try to do is sanitize the record. And this can be done in a number of ways. Going back to the controlled substance statute, if it's not clear under South Dakota law whether or not you have to admit the precise substance possessed in order to meet the elements of the crime, then it would certainly be worth arguing that the element of the crime really is the schedule, 3 through 4 or 1 through 2, and not making admissions to the actual substance possessed, and trying to take out the actual substance possessed if possible. I know that's really tricky sometimes, very difficult to get items removed from a charge, but again, that's something that is very worthwhile if you can litigate that issue and get that record sanitized. Cleaning up that record. Sometimes If the prosecutor, and again, this is extremely difficult, but sometimes if you have a very damning charging document, but there's some negotiation that the prosecutor is willing to offer a different charge, are they willing to actually, take away the original charging document and issue a new charging document that's much cleaner for your client on the new charge? That's very helpful. Crafting a plea with minimal admissions. A lot of times, this is something that we worked very hard with the bench on and with prosecutors when I was at the public defenders, not going into court and making a lot of admissions about Padilla advisals and immigration status. That's very damning to clients often, and immigration can use that information against non-citizens. So, we would typically ask the bench for an in-chambers conference with the prosecutor and, talk about, yes, we've met our obligation, our file is fully documented with the Padilla advisal, if there's ever any questions that come back in the future, but please don't put that on the record. And also then, having an agreement as to what admissions were going to be made on the record. And then finally, a very important tool in the toolkit is limiting the sentence. So again, looking at the immigration statute to find out what is the trigger that is going to attach this immigration consequence to this individual. Sometimes it's the term of imprisonment of a year. Sometimes it's 180 days. And just knowing that trigger and trying to craft a sentence around that. Sometimes we didn't get agreements from prosecutors on that, and then but we did try to work to make sure the judge realized what the trigger was, and sometimes in straight pleas the judge was willing to work with us on that. What are some of the resources that are available to people? First of all, a National Lawyers Guild, they have a National Immigration Project, which has a number of criminal law resources, CrimImm resources. They have practice advisories on almost every major Supreme Court decision that has come out within the past 10 years. Those are extremely helpful. They also take calls if you are looking for assistance in crafting a plea or are looking for somebody to talk to get guidance on how might I deal with this particular situation. They just have a wealth of information. They're a very good resource. They know a lot of the hot topics that are going on right now and being litigated throughout the country. So that's a resource I would very highly recommend. Another resource is the Immigrant Legal Resource Center. That's located in California. Again, very familiar with what's going on in CrimImm law throughout the country, but a lot of their resources tend to be California centered. Still a good place to look at arguments and to get a feel for how courts are deciding decisions. Good resource. Another resource is the American Immigration Lawyers Association and also the American Immigration Council. The council is the foundation arm of AILA. They do litigation and also practice advisories and have done a number of things within the CrimImm arena. So that is another area where you might be able to find some free resources and to connect into individuals who are litigating these issues day in and day out for some help. I know I've kind of thrown a lot of information out there very quickly. I hope that there are some questions and that we can kind of make this a little more interactive at this point.
So this is Beth again, and this is your opportunity to be able to type in any questions that you may have to the questions column on the toolbar for GoToWebinar. Kathy, I was wondering if you could discuss how the use of courthouses by Immigration and Customs Enforcement has changed, and what you're hearing and learning about that no longer being a safe space, and maybe any kind of public policy that's been going forward to make that a safe space for people.
Yeah, yes, thank you. That's been one of the hot topics that has been going on. There have been a number of arrests at courthouses throughout the United States, and Immigration and Customs Enforcement has given a couple of different rationales for the arrest. One is that courthouses are safe places to pick somebody up because an individual has to go through metal screening, so that's why they like to go to courthouses, because they know the person is going to be unarmed. Another rationale that has been given is that for places that are known to be sanctuary cities, so where they're, for instance, Minneapolis is a sanctuary city where the city has determined that local police are not going to be enforcing immigration laws. ICE has taken the position that that lack of cooperation forces them to go into courthouses to make arrests, because that's the only way they can really find people. As far as what is happening, a number of courts have raised concerns, and this started early on, like right after the administration started this policy last year of going into courthouses. Several courts throughout the country started writing Immigration Customs Enforcement, asking them to stop going into courthouses because it was limiting access to services for citizens and non-citizens alike. And it was hurting people that were generally going in to get family court. So for instance, somebody who needed an order of protection from an abusive spouse, people weren't willing to go in to avail themselves of those protections any longer. ICE has not backed down. There has been some congressional interest in this issue. I know there was a breakfast in Minnesota earlier this summer where the congressional offices discussed limiting or designating courthouses as a safe place. Several years ago, there was legislation that identified schools and places, churches, places where weddings are performed, as a safe place. And so there's some thought that legislatively that courts may be added to that list, although that is not moving forward at this time as quickly as immigration advocates had hoped. There also is a case pending in Maryland in the federal court where the public defenders have actually sued to stop immigration from going into the courts, and that case is moving forward. It survived a summary judgment, so I'm not sure exactly when that's set for a hearing now, but if anybody is interested in those pleadings, I'm certainly happy to get a copy of those to you.
Great. And we do have a few more questions. The next question is, can you please address state hunting violations as a firearm conviction?
Hunting violations of the firearm offense? Yeah, that's a great question. And firearm is federally defined. So in order to determine whether or not a state hunting violation is going to be a removable offense for a firearm violation or something that prevents somebody from getting immigration relief for a firearm conviction, you have to take a look at that federal definition and the state definition and determine whether or not the state definition prohibits items that are not included on the federal list. Okay, I'm not familiar with South Dakota's definition of firearm, but as an example, I can give you a Minnesota case that I had where it was a prohibited person in possession of a firearm. And that person was charged with being removable for a firearm offense, and we actually successfully argued that he was not removable for that. And the reason why was because Minnesota definition of pistol is overly broad. It includes weapons that are fired by a band, an elastic band, and that is not included in the federal definition. So that meant that there was not a categorical match. It didn't matter what my person actually possessed. What mattered was that he could have been convicted of possessing a weapon with a band, and federal law does not prohibit such a weapon. Okay, so
That's really interesting.
Yeah, so if somebody has that definition of, South Dakota, I'm perfectly happy to take a look at that and, forward the relevant federal statute to them. But I just don't know off the top of my head, but that's the analysis you have to go through.
Great. The next question that we have here is, can you discuss whether a conviction can be set aside because a judge did not advise the defendant that there may be immigration consequences to the plea if there is no lawyer?
Yeah, that's a great question. And that's something that there's been a lot of back and forth on. I think that what is really important is to identify what are defendants' rights when they're appearing. And so Padilla, which talks about the need to advise regarding immigration consequences, is tied to the Sixth Amendment right. So it's tied to the right to counsel. It's not really applicable to judges. To judges, it's really the Fifth Amendment and the right, the need to provide a fundamentally fair hearing. And so under, for instance, in Minnesota law, we have a requirement that judges are required to give an advisal that that conviction may have immigration consequences, and they should offer a defendant an opportunity to get immigration counsel. And so that's really, I think, if you have a person who is unrepresented, they appear in court and there's no mention that this could have immigration consequences, then, I think there is an issue under the Fifth Amendment that they may not have had a fundamentally fair hearing.
There was a follow-up to that. You had mentioned Padilla as setting the standard for lawyers to provide that information. Is there any case law to support setting aside a conviction if the judge doesn't say anything to the defendant?
I think that there have been some cases that have set aside for due process violations, or where the judge has given wrong information to a non-citizen, stepping in that role, saying like, well, you will be deported, or maybe not. So I think there have been some cases like that. I don't have a site off the top of my head, but I could try to find those for you. An area that I also think is kind of interesting is when a person is, and I'm not aware of any cases that have found this, but in some instances where the prosecutor steps in the person is unrepresented, and the prosecutor steps in to make an offer to the person and, tells them what the consequences of that offer are, so to speak, or what the terms of that offer are, are they, picking up a Padilla obligation if they're advising that person? I mean, it's an odd, it's still a prosecutor, but, is there some issue there where they have an obligation to say, hey, there may be immigration consequences, you should talk to a lawyer?
Right. And then we have one more question here, and we might have another one that just popped up here. But the second to the last question currently is, can you discuss post-conviction relief a little bit?
Sure. Post-conviction relief, if the purpose of the relief is to avoid an immigration consequence, is somewhat tricky. And the reason why is there's a Board of Immigration Appeals case called Pickering, matter of Pickering, Pickering, that says that if a conviction is set aside in order to avoid immigration consequences, it's not effective in avoiding immigration consequences, okay? And so that case is limiting, obviously, but it's also confusing, because I think sometimes people come in and they move to set aside a conviction based on Padilla. The person wasn't adequately advised of immigration consequences, and then there's something, will just Pickering get in the way of that? And the answer is no, because a Padilla, if you're getting post-conviction relief based on Padilla, you're actually getting the conviction set aside because of a Sixth Amendment violation. The person's right to counsel was violated. And so that is effective for avoiding the consequences, immigration consequences of conviction. Likewise, in cases where we move to set aside convictions. An example, recently I had a young man that had 2 marijuana convictions, and those were set aside for because the conviction was entered automatically when he failed to appear in court in one instance, so it was a lack of due process. And in another instance, he wasn't provided an advisal, so it was lack of due process on that. And the court did set those aside, and they were, both of those convictions were, the reason we wanted them set aside is because he was subject to mandatory immigration detention and removal, but we found a constitutional reason to set them aside, and he's now been released from immigration custody. Another important thing on sentencing, just to chime in, is if the immigration consequence is triggered by the term of imprisonment. Okay, so let's say that you have a defendant that was convicted of, I don't know, theft, and he received a 365-day term of imprisonment. That's an aggravated felony crime of theft, because theft, aggravated felony, is triggered by a term of imprisonment of a year. You may not be able to get that conviction set aside, but you want to get rid of the aggravated felony, you might be able to re-sentence him. Could you get an agreement instead of, a year and a day or whatever the term of imprisonment was, to get it down to 364? And if the only post-conviction relief you're getting is not the set aside of the conviction, but the relief is limited to sentencing, a change in sentencing, that can be for immigration purposes only, okay? And that's a different case. So Pickering is not applicable to sentencing modifications. That's an important tool to remember.
Yeah, definitely. And we have one more question that's been asked. Can a person get relief even though they do not fall under a specific visa category?
I'm sorry, the question, can a person get relief if?
Even though they do not fall under a specific visa category?
Yes, sometimes. When I hear the word visa category, I'm just going to give a little bit of background here because I'm so steeped in immigration, I'm never sure if I'm really clear, and I hope I am. But when I hear the word visa category, I'm thinking of the different statutory terms that are laid out in 101 that provide people ways to lawfully enter the United States. So a student, a fiance, a lawful permanent resident. There's literally from A to V in visa categories. So that's, when I hear that, that's what I'm thinking of. There are a lot of forms of relief that don't have anything to do with a visa category. So for instance, somebody who has lived in the United States for more than 10 years, and they may be able to apply for relief from removal if they end up in removal proceedings. In order to do that, that's called cancellation of removal. In order to qualify, they're going to have to prove that they were not convicted of a crime that's on INA 212 or 237, and that they are a person of good moral character. So going back to those definitions, you'd have to go through both lists and look at the definition of good moral character to make sure, again, sentence is probably going to be the most important. And then they have to have a qualifying relative, a lawful permanent resident or U.S. citizen, spouse, parent, or child who would suffer extreme hardship if they were removed. So that's an example of relief that's not a visa category, but it is a statutory basis for relief. There's also cancellation of removal for permanent residents. So somebody who has lived in the United States for more than 7 years after admission and 5 years as a lawful permanent resident. They may be eligible to keep their green card even though they're deportable as long as they're not convicted of a aggravated felony.
Great. And the last question, which is a great way to end the presentation, is how can we get a hold of you for the briefings of these complex issues?
I am at the Bangor Center for New Americans, and my email is Moccio, Moccio, at umn.edu, and the clinic number is 612-625-5515. And I guess one thing that, as a resource that I want to mention is, the center, our work is, I work with the detainee rights clinic, so, we go out to the detention facilities quite regularly. People from the Dakotas are typically held in Minnesota, and a lot of times where we see individuals are Sherburne County in Elk River, Minnesota has a large population of immigration detainees, and frequently there are individuals there with pending criminal charges. Candy, Ojai County also has a fair number of immigration detainees, Carver County Jail, and Freeborn County Jail in Minnesota. So it's not uncommon for us to see an individual who has a pending charge in South Dakota. And a lot of times what we hear is their paperwork is taken from them when ICE picks them up at the jail or picks them up at their home after they've been released on bail. But most commonly they're getting picked up when they're released from jail. And they don't necessarily have the name of their defender. And so if you have a client that you are looking for, you think that they may have been picked up by immigration when they were released from custody in South Dakota, please call us, because we work with a number of nonprofit organizations that also go out with us to the facilities, and we will try to find that person for you.
And so we do have just a couple minutes left, Kathy. So I wanted to just see if you have any final thoughts regarding the presentation or other items that maybe were triggered during those questions.
I think that, one of the things that, I guess, maybe just a couple of tools that we used in the toolkit when I was at the public defenders, going back to how people end up in the system. Sometimes I think it puts criminal defense lawyers in an odd position because, typically people are very interested in getting out of custody, and that's usually the number one instruction that they have is get me out and then we'll sort this out down the road. And sometimes with a non-citizen client, we found ourselves in the odd position of saying, look, you really need to think this through, because if you pay that bail, you're going to go to immigration, and the chances of getting out of immigration are, very small right now. Let's sit here and let me work on this charge to get a good resolution, so that when you go to immigration, you're in a better position. Or at least trying to make a connection with an immigration lawyer, very early, so that they can be, involved in that release process, because that can be, I think one of the most critical decisions, because the number of people held on charges and the number of people that are being pushed to talk about a charge in immigration court. And, I assume that everything that they say in immigration court, potentially goes, ICE is sitting right there, and that goes right back to the prosecutor. So it can be really detrimental to the individual's defense. So, that's something I think, often gets overlooked, but really, thinking that through from the get-go. And, likewise, if you're representing somebody in family court, if there's an order for protection that's being issued, thinking through up front, how can this impact my client down the road? One of the things that we regularly looked for if we were defending somebody on a violation for an order for protection is, was there a provision in that order that was not related to the protection of domestic violence? So, for instance, getting a child support clause in there that maybe you could argue, well, that was the violation and not necessarily something that protected against domestic violence. That can be very helpful in avoiding making somebody deportable for violation of an order for protection.
That is excellent advice for us to end this presentation on. Kathy, thank you so much for joining us today and being a part of our Law for Lunch series on behalf of the State Bar and of the CLE committee. Just wanted to thank you for your time and for being with us today.
My pleasure.
And this presentation is recorded and will be available on the State Bar YouTube channel within the next 30 days. So if you need to go back to review any of its contents, it will be available on that platform. With that, thank you to those who attended our Law for Lunch today, and have a great rest of your day. Bye-bye.
Thank you very much.